Okay, so good morning and a very warm welcome to this innovation workshop sponsored by Appleyard IP on the second day of the digital days in the lead up to Helix 2023. So if you are returning from having joined some sessions yesterday, I hope that you enjoyed the content. It was certainly a very diverse range of speakers, very interesting and insightful presentations on how those companies were helping to enable translation and the impact that they're making in that space. So I'm delighted that we are joined by Simon and Alice today to guide us on this presentation on the Optimum Freedom to Operate roadmap. So this is a very snappy title. So I look forward to hearing the insights that you're going to share with the audience today. So as with all the workshops, we want it to be engaging and for participants to feel like they can contribute. So don't be shy, and the chat box is enabled. So we welcome your comments, insights and questions. Throughout the presentation, you don't have to wait until the end. If we feel, or if Simon or Alice feels it's appropriate, they can dive in and pick them up throughout the presentation, or we can wait until the end. So with that, I think, am I handing to you first, Simon?
Yes, please. Yeah.
Yep. So over to you to drive, and really looking forward to it. Thank you.
Great. Well, thank you very much, Alicia. So welcome to our innovation workshop, which is directed towards the Optimum Freedom to Operate roadmap. So after this session, hopefully you'll be able to successfully navigate around any patent issues so as to reduce risks associated with product development and product launch. Alice and I will run through the following agenda. But as Alicia said, please do provide, ask any questions along the way, or we can pick up questions towards the back end of the presentation. So first off, we're just going to give a bit of background to set the scene for freedom to operate and searches generally. We're going to touch on risk, and I guess that really boils down to what your appetite for risk is for whatever project you're working on. Alice is going to then talk about enforceability of patents and how that impacts our decision and analysis when we're looking at FTO. We're going to touch on searching, also the analysis of the search results, how competitive analysis can dovetail or input into our FTO work. We're also going to look at documentation, so how should and could you store the information that we find and the analysis that we generate during the FTO. Looking at reporting, so who are we reporting to, what stuff should we be reporting, future actions, FTO landscaping, invalidity actions, and lastly legal remedies. And as I previously mentioned, we can finish off with a Q&A, but please do ask any questions along the way if you have any, and we'll try and field those questions as we go along. So what does freedom to operate mean? Essentially, it is simply what it says, which is it is giving you the freedom to operate, so the freedom to launch a product without necessarily infringing a third party's patent. What does FTO mean to you and your company? I guess it depends whereabout in the journey you are for the product, or where you are in the journey as a company as to where, what the FTO does mean to you. It could be that you're obliged to have an FTO position depending on your corporate governance or procedures. It could be that you require the FTO for funding, so an investor won't invest unless they've seen that you have undertaken some FTO work, or maybe they actually want to go and see the FTO and pass it to their advisors for them to look at it and scrutinize. It could be that you're contractually obliged to provide an FTO. Maybe you're contracting with a third party, and that party requires you to provide some assurance. Maybe it's even some form of warranty that actually you are free of any conflict, and that you can provide services or license the technology to them. And of course, there are different approaches for different companies, product launches and geographies. So it could be that we are much more cautious with a product launch in, say, the US, whereas we may be a little bit more relaxed about a product launch in, say, a developing country, simply because of the risks would be much lower, and also maybe the enforcement angle isn't quite as robust. So what's your risk profile? You know, you got to think about the potential for being sued or for a legal action to be launched against your activities. Could end up with a financial and also time penalty for your company. So you need to assess, what your risk profile is. You have to bear in mind that your own patent applications and marketing activities could be picked up by third parties. And frequently, Alice and I will get approached by current clients who have maybe attended conferences, maybe they've attended seminars or trade shows, and they're providing us with literature or prototypes, and just turning around and saying, does this, or do you think this infringes our patents? So we obviously go away, and as a first port of call, it could be that actually, just your own activities could actually be flagging to third parties that you're operating in a particular space, and that space could actually be covered by one or more of their patents. As I previously mentioned, it's a financial and resource drain. I think people often get very fixated on the financial drain of patent litigation, but actually it's a resource drain as well. You probably have your top R&D people, or maybe it's your chief scientific officer, more likely the CEO as well, getting involved, embroiled in lengthy discussions. Maybe they're actually going to be attending the legal proceedings themselves. So if you can minimize that, that is probably greatly appreciated, not least by your investors, but also the rest of the management team. It can also be a project validation in respect of you're moving the project forward. It's almost like a tick box exercise where you're looking at getting close to launch or close to licensing, and actually it's a tick off, de-risking the project before launch, in order to give you business certainty. It can also give you leverage and can also be used as an asset. And frequently, we see it with our clients who are looking to license or sell an asset to another party. If they can show very quickly and easily that they've already undertaken the due diligence, they've already undertaken the FTO search and analysis, then it puts them in very good stead for continuing with those negotiations, simply because it looks like you've got all your ducks lined up in a row. So looking at risks, setting your risk profile, what risk are you happy with? You'll probably be looking at assessing other parties' patent portfolios and families, and managing the risk from those patents which have been identified. What risks do you want to avert? So I mentioned about the cost and resource drain on the company. Court proceedings can be lengthy and expensive. Obviously, you're paying patent attorneys, other lawyers, maybe barristers, gets expensive. Injunctions are probably the primary reason why you want to avoid legal proceedings, simply because if another party gets an injunction against you, then they can pull the product from the shelves, they can stop you from launching the product, and if they are successful in those legal proceedings, then actually that injunction will be in place until the patent has expired. So injunctions are pretty damaging, especially if you've spent a lot of money and a lot of time investing in a product launch. Also, risks of threats, so third parties threatening legal proceedings, not quite so bad, but sometimes third parties can actually approach your customers as well, in order to say, well, you shouldn't be buying or licensing the technology from you because there are patents and there's a potential infringement risk. Bad publicity. A lot of big companies don't like the bad publicity of infringing maybe a smaller company's patents. I've seen it in the past where there were share price fluctuations on the back of either successful or legal proceedings being lodged against a third party. It could be that there's actually a breach of contract. So if you've got a contract with another party, does that contract stipulate that you won't infringe third-party patents, or that you are doing your best to sort of mitigate any potential risks. And of course, there's always that risk of a deal failure. If you can't show that you have an FTO position in respect of a particular company or a particular patent portfolio, then that deal could be at risk, and and the party you're trying to put a deal in place with could go to a less riskier company or look for a different deal. So with regard to risks and costs, costs could come in many forms. So in the US, for example, we have something called treble damages for willful infringement. And this is where in the US, if it can be shown that you should have known about a patent, or you knew about a patent and infringed it anyway, then a court can award you treble damages, which is essentially, they will look at the quantum of damage that was inflicted, and then they'll say, okay, well, times that by 3. And that can be incredibly punitive. And whilst on the face of it, FTO search and analysis sounds expensive, it could range anywhere between maybe 10 up to maybe 30, 40, 50,000 pounds, depending on how large the FTO search is. It depends how much analysis is undertaken by, say, UK attorneys, European attorneys, or maybe US attorneys. That is really a small price compared to the price of litigation, or trying to fight the litigation. You could also look at designing around products and processes. It can delay product launches, which can obviously impact the bottom line. I mentioned injunctions, which can be terribly disruptive. And lastly, it could be that actually there are problem patents out there, but we don't want to get into a litigation situation. Let's in-license the IP from a third party. That could certainly be another option. So Alice is going to touch on enforceability now. So over to you, Alice.
Hi, everyone. Now I'm going to talk about the variables in enforcing a patent against potential infringers in different jurisdictions. Now, the quality of the courts in different countries can vary, as can the time for a case to be heard. A long delay in getting a case to trial may be a deterrent to the patent holder and may put them off taking any action completely, or may make them more amenable to an early settlement without any costly and time-consuming litigation. The enforceability of a patent is variable between different countries, and the decision on the infringement or the validity of a patent in one country is not binding on another jurisdiction. So the advice may vary depending on where the patent is in force and where a product is planned to be launched, and where you might carry out manufacturing. These factors will all then feed into the assessment of how risky it is to launch or manufacture a product in a certain country. The essential question is, what is the likelihood of an infringement action being successful? The variability in enforcement can be off-putting to the patent holder. Litigation is costly, as I've said, and it can take a long time. Obviously, these vary between different countries. And then if the patent is enforced and potentially infringed in many countries, the number of different litigation actions necessary, with all the costs and the time involved in this, would be very discouraging. So that may put the patent holder off. But equally, in different countries, you may have a system which is more favourable to the patent holder, in that the claims are interpreted more broadly. They're not just given a literal interpretation, and therefore that can be off-putting to anybody wanting to launch a product there. This situation can be exploited when you've identified the differences in different countries and their litigation systems and in their interpretation of patent claims, when looking at the risk of, for instance, launching a product or maybe manufacturing a product in those countries, and can influence your decision on where to go. It is therefore useful also in your assessment to consider any recent local law changes or case law where you're planning to do a launch. These different decisions can change the landscape, and in that they can make it more favourable to the patent holder or more favourable to somebody wanting to launch a product there. And do they have any impact on the current validity of a patent? And they may have an impact on the interpretation of infringement, which can change dependent on different decisions made in the courts. Next slide, please. So what are you actually going to do to identify patents that could be a problem where you want to manufacture, where you want to sell? So you need to search what patents are there. And how are you going to do this? There's an awful lot of patents out there. Now you can do this internally. You can outsource it to an external service where they are, that is their specialism. It can be very complicated. So this slide sort of highlights the things you need to think about and focus on to make your search as effective and as efficient as possible, because it can take a lot of time, and time is money. So you want to look at which classifications of patents are you concerned about? What are you going to search? How many are you going to search? What keywords have you identified which can be used to identify any problem patents or patent applications? Another thing to consider is the age of that patent. Is it coming near to the end of its life? You know, does this impact on what you are proposing to do in that jurisdiction where it is currently in force? It can mean that you can discount it completely because it's due to expire before you are even planning to do anything there. Are you going to search one database or multiple databases? The more you search, the more expensive it will be, the more time it will take. You can search on the basis of the applicant. You might want to search on the basis of known competitors. All of these factors can help you narrow the search. Obviously, the bigger the search, the longer it will take, and the longer the analysis will take for analysing all those results that you've generated, and therefore the more it will cost. So really consider what the most effective search is. At Appleyard, we always have at least 2 attorneys analysing the information so that we can come back with an informed and reasoned opinion, because the interpretation, the analysis side of it, it can take, you know, it might need sort of R&D knowledge, it might need legal knowledge, it might need sort of specialist knowledge of the case law and the current interpretation of claims in that country. It's yeah, it can be quite complex. Next slide, please. So in your search, the timings are really important. One thing to bear in mind is that unfortunately, the search can't capture everything. So any patent application that is not yet 18 months old will not yet be published, and so it cannot be found. So it makes it necessary to do later searches to try and find these patent applications that weren't visible when you did your first search. It's important to check the status of these patents and patent applications. Are they in force? Are they going to be in force when the product is manufactured in a jurisdiction of interest? Are they going to be in force when the product is launched? Are they coming up to the expiry date of the 20-year duration of a patent? Have the renewal fees been paid? If they've not been paid, can they still be reinstated? All of these things you need to flag up in your analysis. You also need to factor in that people can obtain extensions to that patent term. For pharmaceuticals, they can get what they call a supplementary protection certificate, which can extend the patent term by 5 years. So it's really important to identify if the patent is in force or ceased. You don't want to waste time analysing in depth a problem patent or application that actually is no longer in force, it's been dropped. Make sure that you only analyse the ones that could be a problem for you. And we're not sure where this is from, but apparently only a quarter of European patents are maintained for the full 20 years. This, it's a really important check. So it's not common for patents to be in force for the full 20 years. So it's important to keep a close eye on what's in force, what isn't in force. Okay, next slide, please. So the other thing to look out for that you need to think about is, where actually are you going to search for these problem patents? Where should you search? Are you planning to launch and manufacture and sell your products in the same country, manufacture in one country, sell them in various other countries? You need to search all of those potentially, but if that means a lot of countries, that's going to be very expensive. It may mean you need to obtain translations of documents, which adds to the expense. You may need advice from local attorneys, again, adds to the costs. So initially, at least, you could just focus on the main jurisdictions where most patents are always filed, which are the international PCT applications, the European applications, American and Japanese. And then if you identify issues with any of those, then you can then look at the patent families and search those family members, look where those problem ones are pending or in force. So you can just quickly, hopefully, identify any that are a problem and just search those. But you could search in all countries, but this, as I've said before, will be really expensive. Okay, next slide, please. So again, like, how are you going to conduct this search? How are you going to make it more efficient? You can focus on your competitors. They're involved in the same field. Make sure you look for the correct company names. They may have multiple company names because they have an R&D arm, they have a commercial arm. You can search for inventors in that field that you know of, that have worked, they may have changed companies, but you know that they're in that field, they're doing that work. You can search for institutes and universities that are collaborating with your competitors. They may actually own the IP, and they may be conducting their own research, which actually could influence your decision, the risk to your products with their IP. Same goes for contract research organizations and manufacturers. They may have IP. The licensors, licensees that have now got these patents, what are they doing? Are they also carrying out research in this area? Have they also got their own patents? You can track their filing profile. So it's quite common that people will always, for instance, they might start off with a local application, they may then file a PCT application, and they may then always file in particular jurisdictions, and that can help you identify where you should search, and sort of helps you narrow down that search and make it quicker. Okay, next slide, please. Again, as I mentioned before, you can conduct the search yourself, or you could use an external service. There's lots of specialists in this area. You can, for instance, conduct the searching from the UK, or you could ask local attorneys in the jurisdictions of interest to conduct searches there. That might be beneficial, for instance, where they're in the documents they're in a different language, which you don't have knowledge of, but obviously the local attorney will have, so they can help identify any issues. As stated before, timings are very important. When do you plan to manufacture and launch your product? When are the problem patents expiring? When are problem patent applications potentially going to grant? Are the renewal fees up to date? How long have they got until they could potentially reinstate a patent which is they've not paid a renewal fee for? Monitor those tricky applications up to grant. And then the big next stage, once you've searched and found these documents, how are you going to analyze them? This takes a long time, and you may need to vary your analysis depending on which jurisdictions are of interest and the way that they interpret the claim scope. You may need local knowledge to help you with that analysis. Discovery issues here. So I think this is something to be wary of, that if an infringement action is taken and it was shown, for instance, that you've conducted a search, you were fully aware of a patent and the risk involved because your product was potentially going to infringe this patent, could this search be used in disclosure during any future litigation trial and used against you? Keep updating the search. As I said before, new applications will keep being published. Others may expire. For other applications and patents, they might not pay the renewal fee, so they may no longer be an issue. And you might have to change your search if the product changes, if the manufacturer of it changes. You can set up ongoing alerts for any applications that you think are going to be problematic, so you can see if they've had to amend their claims in a way that means that they're no longer a problem, or maybe they're more of a problem, or maybe they're about to grant, and you've now got to be sort of on notice to launch an opposition action for, say, a European patent in the 9 months post grant. So monitor those problem patents and potentially look to intervene. You have to judge whether it's better to intervene pre-grant, post-grant, use the opposition period for European patents, and be ready to go with this if necessary. Okay, next slide, please. So again, like the analysis is a big job, as I mentioned. Who's going to analyze all those results of the search? Consider what skills the analyzer has. Who's best to analyze the results? Is it the searcher themselves? Is it somebody in research and development who's got that greater technical knowledge of the products and the manufacturing process? Or is it an attorney because they have more experience with the legal interpretation of the claims of a patent? And you might want different people to work on different stages of this process. So for instance, in a first cut where you just look through, see what's in force, what's not in force, maybe the searcher could do that. And then you might want to do a more in-depth look at, we would want to do a more in-depth look at it afterwards. Maybe you get the attorney to do that. If they're questioning some technical terms, then you get somebody from R&D involved. So you might also, if you really have identified something which is looking like a real problem, you might want to get in touch with a local attorney in the country of interest, or you might want to consult with a barrister to see what they think. They've obviously got more knowledge of how court proceedings might go. Okay, next slide, please. So the analysis side of it, the technical side, as I say, first thing is check the status. If it's ceased, if it's in force, hopefully that means you can quickly eliminate ones that you don't need to consider at all. Look for these vulnerable patents that are looking that they might become abandoned. For instance, they've not paid the renewal fee, they've not responded, for instance, to an examination report. And then you can look at if you think it's beneficial. For instance, if you've identified an application that looks like the claims could be an issue for your product, should you intervene while that patent application is pending? You could file third-party observations, for instance. That has a risk that maybe the claims could be amended in a way that the resulting granted patent might be even stronger and harder to get rid of after grant. Or you could take action after grant, for instance, in a 9-month opposition period after the grant of a European patent. But third-party observations are free, and it's costlier to take action after grant. Okay, next slide, please. So as part of the analysis, it's also, spoke before, the laws change, the interpretation of the law changes with regard to how broad your claim scope is, how it's interpreted, and also what is actually acceptable, patentable subject matter. So there's been changes in the US to what's actually eligible subject matter and patentable subject matter in Australia. The interpretation of ranges can be different and can change in different jurisdictions, and methods of treatment. So lots of jurisdictions, methods of treatment are not allowable, for instance, in the UK and Europe. But they're all subjects which could be used if you're looking to invalidate a patent, get rid of something that's causing you difficulties. As mentioned before, different countries have different interpretations of the claim scope. They might have a literal interpretation, so a very narrow interpretation of those claims, which means that it's less favourable to the patent holder, or they might have what they call a doctrine of equivalence approach, where anything which might fall within the same inventive concept might be considered as infringing, which is more favourable to the patent holder and more discouraging to anybody wanting to launch a product there. How enforceable that patent is, how difficult it is to navigate the court proceedings in those countries. Again, I mentioned it varies in different countries. Okay, next slide, please. So, big question, when you're looking at the different patents and applications identified, how broad are the claims? Again, different people might, if you've got a legally qualified person and somebody from research and development looking at those claims, they might have a different interpretation of those claims. The knowledge of case law might be useful in determining how those claims will be interpreted in different countries. For instance, in the UK, things have changed. It used to, I think, be a more literal interpretation of the claims. Now it's this doctrine of equivalence. So you need to use that knowledge to try and produce a conclusion whether you think that product could infringe those claims in that particular country. As I said, research and development input is really useful because they've got a greater technical knowledge of the product, but it has to be tempered because of they don't have such a legal background on claim interpretation. But they're also really useful because they're more likely to know relevant prior art that might be useful in an invalidity action if you need to take that. And again, you might need to get some outside opinion, a local attorney or a barrister for some trickier points. Okay, next slide. I think that's you now, Simon.
Yeah, this is me. Sorry, I was in the middle of answering a question. So competitive intelligence. So you may think, what can competitive intelligence add to a freedom to operate search? But it can actually feed quite nicely into the actual search parameters, and also help with analyzing and looking at the results. So as Alice has previously mentioned, there's an 18-month publication lag from when the patent's first filed to the patent application is actually being published. So when you're doing the patent search, you're only really picking up documents which have been published 18 months, 18 months ago. So there's already an age which has been built in. You can look at competitive intelligence to highlight competitor key geographical markets. So if you're tracking a particular competitor, what markets are they interested in, whether it's from manufacturing or whether it's actually sales. You can also understand, have an understanding of future product launch timings as well. And that might help you with when you're considering what products you wish to launch. You can help to gain an understanding of the actual technology, maybe disease areas, potential exit areas. Are they looking to license? Who's the potential licensee that they're looking to license to? Also keep track of fast followers. But how do you actually undertake the competitive intelligence? There's a lot of tools you can use actually online. So basic internet searching with Google. You can also put up Google alerts, looking at news feeds. There are also larger sort of commercial databases that will also provide you with details of product launches, new drug approvals, clinical trials which are going through different phases as well. You can do a deep web search, so actually specifically looking for maybe PDFs. So these could be actually reports about projects or reports about new products which companies are developing. It could be Word, rich text, Excel. It could also be actually just looking at people's LinkedIn profiles. So it's amazing how people love to talk about themselves. If you look at their LinkedIn profiles, they may be talking about their new project that they're working on, which is a £200 million project. Looking at repurposing one of their existing drugs in a new medical indication. So it's things like that where just reading between the lines, you can certainly use competitive intelligence to help either define the search parameters that you're currently using, or also identifying collaborators or other inventors that may be inventing in the space that you want to operate in. Looking at documentation, one thing that Alice touched on as well is discovery. So discovery is simply where, if you get embroiled in legal proceedings, it could be that the other party can actually get a court order for them to send an independent adjudicator or an independent person to come into your office and actually look at documentation. It doesn't necessarily, it's not limited to physical documents. It can also be electronic, so they can put a program on your servers and mine your servers for documents which may be relevant to the question of infringement. And what they're looking for really is this sort of smoking gun of, did you know about the patent, and did you say, well, we know about it, but we're gonna launch anyway at risk. So you need to be really careful about considering which, what information to keep and what to discard. I think you need to keep everything very, very factual. So documents relating to search strategies, and maybe when you're brainstorming and trying to come up with a search strategy, that's absolutely fine. Specifications and pending claims and file histories of cases which you're tracking and analyzing, fine. Comments on those documents or comments supplementary to those documents are fine, but you need to keep it absolutely factual. And I've seen it quite a lot when I was in-house, where you'd have people from R&D saying, oh, this is a real problem. We infringed this claim, or we infringed this patent, and actually that's not the advice or the analysis of somebody who is legally qualified. It's almost hearsay from somebody from R&D who, firstly, shouldn't be saying that, and secondly, isn't qualified to say that. And 99.9% of the time, they weren't infringing. It was a pending claim. The claims were too broad for whatever reason, those statements were incorrect and actually could certainly count against you if it was ever discovered. Obviously, you may have a throughput of people, maybe in the legal team, maybe in the R&D and management team as well. So you need to think about how to organize the search data. Where do you store it? Keep it as a work file. Do you need to talk about maybe how you eliminate particular documents, how you include them in the analysis, how do you list and tabulate the results? In the UK, at least, we have a sort of limitation period where it's ideal if you keep documents for a set period of time. It's generally 7 years. You've got to be conscious that in this day and age, people are keeping electronic files for a lot longer, especially as they're migrating to new systems, etc. That may actually be a problem. There may be you may have a process in place which actually does look at deleting or reducing your digital footprint when the time is right. It could be that you have a corporate governance procedure which actually dictates how long documents will be kept for. And you do need to think about, well, maybe you put one project on hold for now for whatever reason. Maybe the funding's not there, but actually you might want to pick that up again. So you don't really want to reinvent the wheel. You don't want to have to do all the analysis again. And actually, if you've already done a lot of the heavy lifting, can you simply just use that and maybe just rerun a top-up search to top up to identify any documents which may have been published in the intervening period? Lastly, electronic versus paper. I know most people have gone electronic. I'd like to say that's the case in our firm, but some people are still holding on to the paper. But if you do have paper copies, that is much easier to shred and get rid of, and actually put a timestamp on when you're going to get rid of it. Electronic is a lot harder, of course. And if you're in a meeting and you're making notes, then it's a lot easier just to have that meeting, make the notes. Maybe you're writing on documents, you make the decision, and then you just you shred the notes so that all you're doing is minuting the fact that you've discussed it, you've analysed it, and you made a decision, and this is the decision. Thinking about reporting and analysis, how and where to record. So you're recording the raw data. You might want to record the more in-depth analysis and work product. What I often do for clients is I'll provide them with an in-depth analysis and work product, so the actual freedom to operate analysis document, but they may wish to share that more broadly within the organization or indeed with investors. So I'll prepare an executive summary that's very, very light on analysis and just comes up with simply, we recommended X, Y, and Z. So at least that they can show investors that they have undertaken the due diligence and they have sought legal advice. It could be that the FTO is part of a stage gate approval for maybe a product launch, or it could be for more internal comments and review prior to being given the green light for launch. There could be other considerations such as regulatory approval, etc. We may wish to take advice from outside or local counsel. So as Alice said, it could be that we want to have additional input from barristers on, say, UK litigation. It could be in the Netherlands. Again, we'd seek sort of barristers in the Netherlands. Maybe there's a problem patent in the US, so we'd want to get some analysis in from a US attorney. Again, how do you report that and how do you store that? Could be updates. Are we running additional top-up searches? And lastly, PR, sort of financial reporting around due diligence. So often it comes to the end of the financial year or reporting, and you have to put something on the balance sheet or carve out for some additional funding if further legal advice is required. When you're sharing the analysis with other people, you've got to be very careful. Maybe you're under contractual obligation, or you need to do it as part of contract negotiations. You at the very least need to have some form of confidentiality agreement in place, whether or not that's a sort of a heads of terms type thing, or whether that's a physical document. Often you can put in place what's called a common interest agreement, which is where both parties agree that you'll share information, It's not to be used against one another, and it's only for the purposes of establishing whether or not you want to move forward with a business relationship. Again, you might want to share it with investors or funders or potential investors and funders. The use of data rooms, at least in life sciences, is used very often, and these are really good for allowing third parties to take a look at maybe the search that you've conducted, any executive summaries, but they're not going to be downloading a copy of the actual documents and analysis. So I'll move on to FTO Landscaping, and I think that one's for you, Alice.
Yeah, that's back to me. Okay, so this is a more generalized search, and this can be used to sort of direct where future research may be focused. It therefore can help to focus where you're going to do your research early on. It's useful where the product is not really defined definitely yet. It can help identify what they call white space, which is where no patents currently exist. So this area where you're free to launch, and can help you sort of focus your research in that direction. It can help to identify who are the competitors, who are the main players, people that you might want to work with, people that you might want to be aware of, that could be competitors that might prove difficult. They might also be able to help you with future FTO searches, because you can search for their IP. Investors will want to know what the landscape is, what's the freedom to operate in this field where you're working, to determine what the risk is, what the potential is. They need to be aware of those risks. And then once the product has been developed, more finalized, then you can then carry out a more focused freedom to operate, like top-up search, so that you can properly sort of more identify what risks are involved. Next slide, please. So doing this landscaping, this more general search, has a number of benefits, which I've just mentioned. So it can help you direct where research is going to be focused. This is going to be, more effective long term. It can also help you, you might have identified what sort of area you want to work in, but there's some difficult patents out there. You can then hone in on those and see if you can get around them by making some sort of, might just be a minor change to get around that patent. So you're making a more informed research and development plan. It can also help, you might be able to clear your path, so that you can get rid of, with some invalidity actions, you might be able to get rid of certain patents so that you are free to do what you want there before you do any launches. It does mean, though, that you are basically doing at least two freedom to operate searches. So costs are actually incurred early on by doing this additional landscaping search, before you then have to do another search when you specifically identified the products that you're going to be making and launching. And then you obviously have to conduct another search for this actual defined product. So it can mean more costs earlier on. Okay, next slide, please. So I've touched on it before. What can you do to get rid of these problem applications or problem patents? And to do that, you need to show in some way that they are actually invalid. And you can do this while the patent application is pending. So there's different opportunities to do this. So for an international patent, you can submit observations using patent scope, third-party observations in Europe and in the US and in the UK. And this is very cheap. I think in most cases it's completely free. I think in Europe and the UK, you can do it while the application's pending. But there are other, in the US, you can also do it. There's sort of more details on when you actually can do that. It's cheap, as I said, which is good. But as I mentioned before, it can actually end up with it almost gives the applicant an opportunity to make the patent stronger, because you're sort of playing your hand early. You might throw in a piece of prior art which is a knockout to their current claims, and therefore they have an opportunity to then get around that piece of prior art, so that when the patent's actually granted, it's actually pretty strong, and you would struggle to knock out that granted patent. And if those claims are still problematic to your product, then you've put yourself in a worse situation. Next slide, please. So the other alternative is that you sort of hold back until the patent's actually granted. This is more expensive, but as I say, you maybe have a better chance of completely getting rid of it. So in Europe, you have a 9-month opposition period, and this is available 9 months after grant. You have this window to do it in, which is relative, it is a lot cheaper than going through courts, and you knock it out for Europe, for everybody that signed up to the EPO. So that's really useful. You're not having to launch court actions in lots and lots of countries. So it's much cheaper to go with this, and you might want to have done some preparation beforehand so that you're ready to go with your opposition action. There is now they've launched the unified patent system in Europe. So you can now, whereas before, once a European patent was granted, and then you had the 9-month opposition period, and you validated your patent in various countries, the only option then was to invalidate that patent, was to go through the legal processes in each individual country. But if a European patent is now opted in to, well, I think they're all opted in now to the unified patent system, and they continue to be in that system, you can do a centralized revocation action against this European patent. The only thing is that not every European country or everybody that's part of the EPO is actually signed up to the UPC. So you might have an action there, but you'd also have to take action, for instance, in the UK, which is not part of this system. So in a way, it's not as good as the opposition period. In the US, there are some options post-grant where you can try and knock out the patent there. So you can go for re-examination or an opposition there. Or you can, you can go through the national courts or the patent offices in the UK and Germany and France. And you can, obviously pursue an invalidity action through the court system with barristers, etc., which is really costly. So, consider your options. What's the most effective way to get rid of it, and what finances you have available.
Sure. So I'll just jump in quickly, Alice. I've got 1 or 2 very quick slides to run through. So legal remedies, there's lots to look at. It could be licensing. You might want to license the technology rather than trying to invalidate. If you've been working on something before the application was published or before it was filed, then it could be that you could actually continue doing that. You could look at offensive or defensive patent filings for any improvements that you've made over the technology. You could look to get a declaration of non-infringement. You can put in things like protective letters to stop people from applying for injunctions. Some people just, acquire the company or the asset from the problem patent holder. Legal remedies for third parties, they can get an injunction against you, damages and costs. So that's a bit of a whistle-stop tour, I think, of FTO and lots of things to consider. We've been answering the questions in the chat as we've been going along, so hopefully that's answered quite a few of your questions. I know we've got a hard stop at 11. If anybody has any more questions, more than happy to field them now, or indeed more than happy to answer them on an email or even a phone call after this session, or at any point. Please do reach out to either me or Alice.
Thank you very much indeed, Simon and Alice, for that very comprehensive overview. That was super. So I'll just put my camera on. As Simon said, if you do have any questions, then we are now up to time. However, there is also the conference app, so please feel free to utilize that to reach out to the speakers as well. And if anything occurs to you later today or in the week, then please use that as a tool to keep the conversations going. And thank you so much to Simon and Alice for diligently answering all the questions in the chat as they came up. So that's my job done.
No, that's absolutely fine. And I think Alice beat me on one of them. I was halfway doing it, and then my slide came up. So
all right.
Yeah, that worked really well. And thank you to the delegates for submitting those questions. Some really good questions there, actually. Of course, depending on the stage your company's at, there's different considerations, territories, regions, lots of different variables. So really, really interesting to see your thoughts as well to the audience. So with that, I'll going to close the session now. So thanks once again to Simon and Alice from Appleyard Lees. And we do hope you will join us again at 11:30 for the next workshop, which is an innovation showcase. And on that, we'll be joined of the BioNews Round Award finalists, and they'll be sharing with us what they're doing in the space of translation. So I'm really looking forward to that session and hope to see you all there as well. In the meantime, keep using the conference app. Thanks all. Take care.
Thank you.
thanks,
Thanks.
Alicia.